Hello future officers, how are you all? My name is Pragya and welcome to our new series Target UPSC 2024. I know the exam is postponed and the anxiety level must be high, but kindly keep the consistency. Keep calm and keep preparing, and then in the end I'm sure all of you are going to achieve a positive result. So in our today's target for UPSC 2024 series, we are going to discuss the current affairs related to the subject of polity. So we are going to discuss all of the important monsoon sessions acts that have been introduced by our Indian Parliament. So these acts include the Government of NCT of Delhi Amendment Act 2023. Who can forget the controversy that is going on between the central government and the elected government of Delhi related to the control of services in the Union Territory. Then we are also going to discuss the Digital Personal Data Protection Act of 2023. Now, no one can use your digital personal data without your prior consent. Then we are also going to discuss the Mediation Act of 2023, the Registration of Birth and Deaths Amendment Act of 2023, the Jan Vishwas Amendment of Provisions Act of 2023, and lastly, the Multi-State Cooperative Societies Amendment Act of 2023. So let us begin our discussion today. So the first act which we are going to discuss is the Government of NCT of Delhi Amendment Act of 2023. It was introduced in the Lok Sabha on August 1, 2023. It was passed by the Lok Sabha on August 3, 2023. And it was passed by the Rajya Sabha on August 7, 2023. So this is the life cycle of a bill, firstly introduced, then passed by one house, passed by another house, finally received the president's assent, and then it becomes an act. So it has already received the assent of the president, and the nodal ministry is the Ministry of Law and Justice, and now it is an act, and this is a very important act that had been in the news throughout the year, okay, because of the controversies related to the control of services in the Union Territory of Delhi. So firstly, let us study about the National Capital Territory of Delhi. So Article 239 Clause AA. Article 239 Clause AA gives a special status to the National Capital Territory of Delhi. It designates Delhi as the National Capital Territory, okay. And this Article 239 Clause AA has been introduced by the 69th Constitutional Amendment Act of 1991. Moving forward, it establishes a legislative assembly for the NCT of Delhi, whose members are elected by the electorates in the constituency of Delhi. Basically, Delhi is the Union Territory that has the LG as well as the elected government, and this special status has been given to it by which article? Article 239 Clause AA. Then if you talk about the dispute resolution, so the proviso to Article 239 Clause AA states that in case of a disagreement between the LG of Delhi and the ministers, the matter shall be referred to the President for resolution. And this provision that has been inserted in Article 239 Clause AA was very controversial in nature, because the critics argue that once you have an elected government, how can you refer the matters for dispute resolution to the President of India? Because in normal cases, the LG is bound by the aid and advice of the Council of Ministers. The President is bound by the aid and advice of the Council of Ministers. So this provision often remains in controversy. Moving forward, let us discuss the key features of the Government of NCT of Delhi Amendment Act of 2023. So basically, it creates the National Capital Civil Services Authority. So let me revise the controversy for you in brief. Who controls the services, that is the Group A service officers in Delhi? The central government. Then came the landmark Supreme Court judgment. The Supreme Court judgment said that apart from the matters related to the control of police, control of land, and control of public welfare, the control over services, that is the services of Group A officers in the Union Territory of Delhi, will be in the hands of the Delhi government. And that is why the Parliament of India enacted this act, so as to regain the control over the services of Group A officers in the Union Territory of Delhi. So basically the act proposes the establishment of this National Capital Civil Service Authority, or the NCCSA, as a permanent authority. So who is the appointing officer or the members of this authority? The central government. And what is the composition of this NCCSA? The Chief Minister of Delhi as its head, then Chief Secretary, and the Principal Home Secretary. Principal Home Secretary. So this is the composition of the NCCSA, okay. And its responsibilities include making recommendations to the LG of Delhi concerning transfers and posting of Group A officers, excluding those dealing with public order, land and police matters, because these three subjects fall exclusively in the hands of the central government, and the central government has complete control over these three subjects. Moving forward, it also gives the final authority to the LG of Delhi in instances of disagreement between the LG's decision and the ministers. The decision of LG will supersede that of the NCCSA. And as I said, who has the control of this NCCSA? The central government. Okay. Then there is modification of Section 45 Clause D. It stipulates that the bodies established under the Parliament laws will have their members constituted, appointed or nominated by the President. That means the Parliament has the power to appoint all of the members of statutory bodies and tribunals in Delhi. And definitely they will be appointed by the President under his warrant of hand and seal. Moving forward, Department Secretaries Authority. So the Department Secretaries are empowered to bring matters directly to the LG, Chief Minister and Chief Secretary without consulting the respective ministers. So the NCCSA also has supersession over any kind of the local cabinet ministers that are present in the Delhi government. Okay. Then recommendation panel for bodies under Delhi Assembly laws. So NCCSA will recommend a panel of suitable individuals for constitution appointment or nomination by the LG as per the provisions of Section 45 Clause H regarding bodies created under the Delhi Assembly laws. So in this case also, who has the final deciding authority? The NCCSA in consultation with the LG of Delhi. Moving forward, what are the concerns about the government of NCT of Delhi Amendment Bill 2023? Because this is currently under the challenge before the Honorable Supreme Court of India and the matter is sub judice. So it is basically challenged on two premises. Okay, first is the violation of the basic structure. So how is it violating the basic structure of our Indian Constitution? As I said that the President of India has no discretionary power. Okay. Same is the case with the LG also. He is bound by the aid and advice of the Council of Ministers. Advice of the Council of Ministers. Okay, as per the provisions of Article 239 clause AA. But the creation of NCCSA undermines this authority because it gives final authority to the Lieutenant Governor of Delhi, and that is why it is in violation of the basic structure. Federalism is the basic structure of our Indian Constitution. So this is in violation of the federal principles that have been enshrined in our Indian Constitution. Ideally, the final say should be the elected government of the Delhi because it commands majority, it commands the democratic power, it commands the voice of the people. But no, NCCSA, the members are appointed by the central government. It has the final say in many matters, especially related to the control of services in the Union Territory of Delhi, and definitely it gives the final authority to the Lieutenant Governor of Delhi, and that is why it has been argued that it is the violation of the basic structure of our Indian Constitution. Then LG's discretionary powers. The Act expands the LG's discretionary powers, allowing him to override recommendations and exercise sole discretion. And mind you, this sole discretion is not available also to the President of India. Okay, in some cases it is available to the governor of a state, but it is not available to the President of India. He is bound by the aid and advice of the Council of Ministers. In fact, LG is also bound. Then how can he exercise the sole discretion on various matters? And it potentially undermines the principle of the LG acting on the aid and advice of the Council of Ministers as mandated by Article 239 clause AA. And this could lead to conflicts between the elected government and the Lieutenant Governor of Delhi. So this could increase the gap that is already there between the LG of Delhi and the elected government of Delhi. Moving forward, let us discuss the Digital Personal Data Protection Act of 2023. Another landmark decision, okay, another landmark legislation that protects your data online. So it was introduced in the Lok Sabha on August 3, 2023. It was passed by the Lok Sabha on August 7, 2023, and it was passed by the Rajya Sabha on August 9, 2023. And what is the nodal ministry? It is the Ministry of Electronics and Information Technology, also known as the METI in India. Okay, moving forward, let us analyze the key features of this DPDP Act. Okay, so the Act will apply to the processing of digital personal data within India, where such data is collected online or collected offline and is digitized in nature. That means it will apply to the processing and storing of your digital data. Storing of your digital data. It will also apply to such processing outside India. That means it has, this law has extraterritorial operation. If it is for offering goods or services or profiling individuals in India. Profiling individuals in India, for example, WhatsApp, for example, Facebook, for example, YouTube. All of these are profiling your profile so that they can show you targeted ads. So basically, this will also have jurisdiction over these MNC companies, okay, or the social media companies. Then it mentions about a term known as data fiduciaries, and they will be obligated to maintain the accuracy of data, keep data secure and delete data once its purpose has been met. Let me explain this to you by a very beautiful example. Okay, so this person A, okay, supposedly goes to this Bank Y, website of Bank Y. He completes all of the know your customer requirements. Okay, now this person A data has reached to Bank Y. Okay, now he will start getting calls for credit cards, loans. Sir, your personal loan is waiting. Ma'am, your personal loan is waiting. Okay, so this, after the enactment of this act, this will not be allowed. If the person goes to this Bank Y and says that whatever data you have, delete it. I do not give you the consent to call me for credit card offers, call me for, unnecessarily loan offers. So the bank will be liable to delete all of the personal data which it has stored for KYC. apart from the use of it for lawful purposes. Okay, and what can be these lawful purposes? Supposedly, A gets involved in the FEMA Act. Okay, he is money laundering from India to other countries. Okay, in those cases, the bank will be permitted to utilize his personal data for giving it to the law enforcement agencies. But if he says that no, you cannot utilize my data for other purposes, okay, then the bank will have to delete his data. Moving forward. So basically, the definition of data fiduciary is, it is defined as any person who alone or in conjunction with other persons determine the purpose and means of processing of personal data. And it includes all of your search engines such as Google. It includes all of the social media sites such as Meta, such as Instagram, such as WhatsApp, such as YouTube. All of these come in the purview of the definition of data fiduciary. The Act grants certain rights to individuals, including the right to obtain information, seek correction and erasure, grievance redressal, and right to nominate a person to exercise rights in case of death or incapacity. So just imagine the kind of broad control this Act is giving to you over your own data that you are supplying online. Okay, and this forms an important facet of right to privacy. Under Article 19, right to be forgotten. And this right to be forgotten was recognized by the Honorable Supreme Court of India in Justice 𝐏𝐤𝐲𝐫𝐞𝐬 case. Okay, it was an important facet of right to privacy, and definitely the Act grants certain rights to individual for handling and controlling their own online data. The central government may exempt government agencies from the application of provisions of the Act in the interest of specified grounds such as security of the state, public order, and prevention of offences. So yes, these are the reasonable restrictions. Okay, in these cases, definitely the data can be shared with the law enforcement agency. And this DPDP Act is the first legislation that is using the pronouns she and her. We see whenever we study any kind of law, let me explain this to you by an example. In IPC, when you will study the definition of gender, he includes she, but in this legislation, the pronouns she and her has been used by the central government for the very first time. Moving forward, the Act is based on the following 7 principles. The first principle is of consented, lawful, and transparent use of personal data. So this is what I am reiterating again and again, that you can control your personal data that you are sharing online. Then it is based on the principle of purpose limitation, use of personal data only for the purpose specified at the time of obtaining consent of the data principle. Then principle of data minimization, okay, the principle of data accuracy, the principle of storage limitation, okay, the online companies or the data fiduciaries cannot store your personal data for an indefinite period of time. They are liable to delete it once the purpose of collecting that data is over. Moving forward, the principle of reasonable security safeguards and the principle of accountability through adjudication of data breaches and breaches of the provisions of the Act and imposition of penalties for the breaches. Okay, the central government will establish the Data Protection Board of India, and this authority is going to be very important in curbing of cyber crimes. Okay, because the laws in India in relation to the cyber crimes are limited to the IT Act and the IPC. Okay, we do not have a dedicated tribunal for adjudication of these matters, and definitely it is going to enhance the cyber security. It is going to limit the cyber offenses those are happening. Okay, moving forward, let us discuss the Mediation Act of 2023. So basically, it was It was based on the report of the standing committee, which was published on July 13, 2022, passed in the Rajya Sabha on August 1, 2023, and it was passed in the Lok Sabha on August 7, 2023, and the nodal ministry is Ministry of Law and Justice. So what is this Mediation Act? What was the need? See, India is trying to become a mediation hub. We are trying to solve all of our cases outside the normal courts. Okay, we are trying to solve those cases which can be solved by alternative dispute resolution mechanism, and that is why this Mediation Act was very mandatory in nature. And India is also a signatory to the Singapore Convention. Singapore Convention on Mediation, which necessitates a domestic law in that regard, and that is why our parliament passed this, the Mediation Act of 2023. Moving forward, let us firstly understand what is mediation. So let me explain this to you by a very simple example. For example, there is this person A and there is this person B. Okay, and they have a dispute that is going on. Dispute can either be civil in nature or either can be criminal in nature. Let me explain to you firstly the civil nature. For example, they are spouses, husband and wife. Okay, so firstly, whenever you will go to the courts for seeking divorce, you will be referred to the mediation. That firstly, have a counselor, have a mediator, talk to the parties, identify the issues, and if they are solvable in nature, do not come to the courts. Solve the issues between the parties. And this is the primary aim of having mediation, okay? And it is an alternative dispute resolution mechanism. Dispute resolution mechanism. Which is also known as the ADR. Okay, and ADR in India is in its growing phase. Let me give an example of a criminal case that can go into mediation. For example, A and B have a commercial transaction. Commercial transaction. A has given a check to B and the check has bounced. Then also you can go to mediation. If B agrees that, okay, I'll pay this amount, the agreement will be formed and that agreement is legally binding. The B then will be bound to pay the amount. Why to approach courts for every matter? Because our courts are already very overburdened in nature. So this is the purpose of mediation. This is the process of mediation, that you are resolving the dispute outside the court. Okay, and it is a voluntary process where an impartial mediator helps disputing parties reach a settlement, and it's binding once an agreement is reached, and that agreement is known as a mediation agreement. In fact, there are other methods as well, such as arbitration, conciliation and negotiation, and all of these methods of ADR are mentioned under section 89 of the Code of Civil Procedure 1908, and their importance was reiterated by the Honorable Supreme Court of India in a very landmark case known as the 𝐹𝐶𝐻𝐿 Infrastructure Limited versus 𝐠𝐢𝐹 Construction. In this case, the Honorable Supreme Court said that if the matter is resolvable by applying the ADR processes, kindly follow the ADR process. Try to resolve the matter by alternative dispute resolution. Moving forward, what was the need of this Mediation Act 2023? Okay, so I already informed you that the India is signatory to the Singapore Convention on Mediation, which necessitated passing of a domestic law. Then there are issues of case pendency. Our courts are actually very overburdened with the cases. Then there is an absence of standalone laws, because mediation is mentioned under many kind of legislations in India, but yes, it was not a compulsory process. Okay, then mediation for true justice, because it can actually grant true justice without following the lengthy process of courts. Okay, you can get true justice by appointing an impartial mediator, and in the case of mediator, the parties choose the mediator. Okay, So yes, you can get true justice without following their lengthy court procedures. Then aspiring international mediation hub, as I said that India is aspiring to be an international mediation hub because we want to promote ease of doing business, and that is why there was a need for passing this act. Moving forward, what are the features of the Mediation Act? So, pre-litigation mediation, parties are encouraged to approach the mediation before jumping into an actual litigation. Then disputes not fit for mediation, certain disputes such as those involving minors or unsound minds, criminal prosecution or third party rights are excluded from mediation. The central government can amend this list. So it also lays down the list of those disputes which cannot be resolved by the process of mediation. Then applicability, the act applies to mediations in India involving domestic parties or at least one foreign party in a commercial dispute if agreed upon in the mediation agreement. Okay, moving forward to the mediation process. So they are highly confidential in nature. The mediators are appointed by the parties themselves and they have to declare that they do not have a conflict of interest with the parties. Okay. Then Mediation Council of India, established by the central government. It includes a chairperson, full-time members experienced in mediation and ex officio members. Functions include mediator registration and recognition of mediation service providers. And we have a huge mediation council in the city of Hyderabad. Mediation Council in the city of Hyderabad. International Center for Arbitration. Okay, and this Mediation Council will be established by the central government. Moving forward, mediated settlement agreement. So basically, the mediated settlement agreements will be binding on both the parties and the breach can be challengeable on grounds, okay, in the courts, and it can also be challengeable on grounds of fraud, corruption, impersonation, on disputes not fit for mediation. So although it is legally binding, it cannot be challenged in courts, but yes, it can be challenges on the grounds of fraud, etc. Then community mediation, attempted to resolve disputes affecting local peace and harmony, conducted by a panel of 3 or more mediators. So these are the key provisions of the Mediation Act of 2023. Moving forward, let us discuss the Registration of Births and Deaths Amendment Act of 2023. Another set of landmark legislation, and it was introduced in Lok Sabha on July 26, 2023. It was passed by Lok Sabha on August 1, 2023. And it was passed by the Rajya Sabha on August 7, 2023. And the nodal ministry is the Ministry of Home Affairs. Moving forward, let us firstly analyze what is the Registration of Birth and Death Amendment Act of 2023. So basically, this act aims to amend the Registration of Birth and Deaths Act of 1969. The Registration of Birth and Deaths Act 1969 regulates and facilitates the registration of birth and death across India. So basically, this Registration of Birth and Death Amendment Act of 2023 is very landmark in a manner because it will promote the true digital registration of each death and birth, because in the COVID-19 pandemic we saw that yes, the deaths were not getting completely registered, and same as the case of birth certificate as well. Okay, people are not registering their births. Okay, and in most of the cases in the 90s you can find that people are possessing multiple birth certificates. So all of these issues will be solved by this act. Moving forward, let us analyze the key features. So basically it provides for digital birth certificate, and this introduction is very important in nature because in 2022 a case came up in Bihar in which the officials were demanding a bribe for issuing birth certificates, which is completely free of cost in nature. So that is why it has introduced this digital birth certificate as comprehensive documents for various purposes reducing the need for multiple documents. So I said that this practice was very common in the 90s kids, that we used to have original certificate, then our age was reduced, and then the birth certificates were made by giving bribes. So all of these false practices will be stopped, because now every birth in India will have a digital birth certificate. Then Aadhaar integration also is a very important key feature. It proposes linking Aadhaar details of parents and informants to birth certificates, expanding Aadhaar inclusion to reporting authorities like medical officers and jailers. Moving forward, then it will also create a centralized database. It established a centralized database for managing birth and death records, updating the National Population Register or the NPR, ration cards and property registration. It will also help us in conducting the census. So census was proposed in the year 2021 itself, but it has been postponed for an indefinite period of time, and that is why this can help in creating a centralized database. It can also identify the actual government benefits, okay, if it is going to the actual people or not. Then obligatory registration. States mandated to register births and deaths on the central Civil Registration System CRS portal and share data with the Registrar General of India under the Union Home Ministry. Okay, so these are the key provisions of this act. Moving forward, let us examine the benefits of Registration of Birth and Deaths Amendment Act of 2023. It will create enhanced administrative efficiency. Okay, then it will streamline citizen services such as the PDS, okay, such as the affirmative action policy of the government, okay, such as educational admissions, okay, government jobs and passports using a single digital birth certificate. And it will also fulfill our dream of becoming a truly digital India by enforcing a digital transformation. But there are some underlying issues, such as it is in violation of the right to privacy. And this is being alleged by the critics that yes, it is in violation of the right to privacy. On one hand, you are protecting the digital data of the persons. On the other hand, you are bringing this bill in which they have to compulsorily register their birth and deaths online. Okay, so this is definitely an infringement of their right to privacy. And then this data can also be modified by the government as per their own needs and benefits. Moving forward, let us discuss the Jan Vishwas Amendment of Provisions Act of 2023. Another landmark legislation to reduce the pendency of cases and to repeal the obsolete laws in India. So basically, the act seeks to amend 183 provisions in 42 central acts governed by the 19 ministries department, covering diverse areas like environment, agriculture, media industry, trade information, technology, copyright, motor vehicle, cinematography and food safety. So see, this is the cardinal principle of criminal law, okay, that law does not favor trifling acts. Law excuses trifling acts from its purview, and this act's primary aim is to decriminalize minor offences not detrimental to public interest or national security, replacing criminal penalties with civil penalties or administrative actions. And definitely it will declutter our courts. It will reduce the pendency which is already there in our courts, okay, due to the huge amount of criminal cases and civil cases. Moving forward, it will rationalize the criminal provisions to alleviate pressure on the justice system by addressing minor offences more appropriately, address technical and procedural defaults, established a balanced approach that aligns with the severity of an offence with the prescribed punishment. Okay, then it will also promote business growth by decriminalizing the minor offences. You can directly resolve them through mediation, etc. Okay, so this legislation becomes very important in nature. it has also repealed the obsolete laws in India, because there is a very important maxim in the law, ignorantia juris non excusat. That means ignorance of law is no excuse. But what if I do not know the laws which were there in the independent India, or which are ongoing from the pre-independent India, okay? So if I do not know the law, definitely I'm not going to be excused, and that is why there was a need to repeal all of those obsolete laws which we were carrying through our British times, okay, pre-independence times. Moving forward, let us analyze the key features. Removal of imprisonment clauses, adjudication by appointed officers, also known as adjudicating officers. Then introduction of compounding of offences. What is compounding of offences? For example, there is this person A and there is this person B, okay, and if the offence is compoundable in nature, okay, so he can ask this person B that, okay, let us settle this outside court, I'll pay the penalty and you discharge me of all of the charges. This is known as compounding of offences. Then periodic revision of fines and penalties and removal of offences under the Indian Post Office Act of 1898. Moving forward, let us discuss the last legislation of our today's session, and that is the Multi-State Cooperative Societies Amendment Act of 2023. So it is based on the report of Joint Parliamentary Committee which was submitted on March 15, 2023. Then it is passed in the Lok Sabha on July 25, 2023. Passed in the Rajya Sabha on August 1, 2023, and the nodal ministry is again the Ministry of Home Affairs. Moving forward, let us study about the multi-state cooperative societies. So, as per the recent judgment of the Honorable Supreme Court of India, in which it said that the 97th Constitutional Amendment Act, which made the provisions related to the cooperative societies, that the Parliament has exclusive power over the multi-state cooperative societies, okay, and it does not have any kind of power over the cooperative societies that are functioning in the states. So basically, cooperatives are voluntary, democratic and autonomous organizations controlled by their members who actively participate in policy making and decision making processes. And an example of a successful cooperative society in India is Amul. Yes, you might find this shocking, but yes, Amul is a cooperative society. And they have a one single aim. It can either be welfare of the people, it can either be upliftment of the weaker sections, and it can either be economic upliftment of the society, okay. So the types of cooperative societies are multi-state, and these societies operate in multiple states of India and sectoral diversity. They can function in various sectors such as agriculture, textile, poultry and marketing. Moving forward, what are the promotion efforts? The 97th Constitutional Amendment Act inserted two articles, okay. First is Article 19, that is the fundamental right of you to form a cooperative society, okay, and it also included a DPSP under Article 43 Clause B, and we have discussed this all in detail, okay. In it also added a new Part 9B to the Constitution titled the Cooperative Societies from Articles 243 Clause ZH to Article 243 Clause ZT, and it authorized the Parliament to enact laws for multi-state cooperative societies and state legislatures for other cooperatives. And we have discussed the judgment of the Honorable Supreme Court in relation to the 97th Constitutional Amendment Act, in which it said that the Parliament has exclusive power over the multi-state cooperative societies, but these provisions, that is Articles 243 Clause ZS to Article 243 Clause ZT, cannot be applied on the cooperative societies that are functioning in the states. Okay, on the state cooperative society, the states have an exclusive control, but it retained these fundamental right under Article 19 and the DPSP under Article 43 Clause B. Moving forward, let us examine the key features. So, electoral reforms and financial assistance. So, basically it established the Cooperative Election Authority for supervising elections to the boards of multi-cooperative society. Okay, and if these boards are not functioning properly, the central government has the right to replace this board, has the right to suspend this board. Okay, if they are not meeting frequently and if they are not functioning properly. Requirement of prior permission for redemption of shareholding by multi-state cooperative societies and creation of a cooperative rehabilitation, reconstruction and development fund financed by profitable societies for reviving sick multi-state cooperative societies. So these are the key features. Moving forward, it also has an allowance for state cooperative societies to merge into the existing multi-state cooperative societies as per the state laws. Then exemption for companies under the Companies Act from contributing towards revival of the sick companies. Okay. Ease of doing business in the cooperative sector, introduction of time-bound registration, leadership by the Ministry of Cooperation, and this Ministry of Cooperation has been recently formed by the Parliament of India. But in the case of Ministry of Cooperation also, it has only the exclusive jurisdiction over the multi-state cooperative societies and not those cooperative society who are functioning under the state laws. Okay, implementation of electronic filing and authentication for various cooperative documents. Moving forward, board member composition and transparency provisions, ensuring representation of women and SC/ST on cooperative society boards, appointment of cooperative ombudsmen and information officers to enhance transparency, accountability and grievance redressal, then empowerment of the ombudsman to enforce attendance and access documents with term-bound grievance resolution, then provision for dissatisfied members to appeal to the Central Register of Cooperative Societies, and this is not central register, it is the central registrar. Okay, then mandatory concurrent audits for financially significant multi-state cooperative societies to ensure financial transparency. So all of these are the key features of this newly introduced multi-state cooperative societies act. Then there is also National Cooperative Database, okay, and inclusivity in decision making, that the establishment of the National Institute of Cooperative Management and Cooperative Education Fund to address training and education needs in the cooperative sector. So all of these are the features of this act, and definitely it is aiming to strengthen the multi-state cooperative societies as well as promote the ease of doing business in the cooperative sector. With this, we come to a conclusion of our today's discussion. We have seen some of the major acts that have been introduced in the Parliament in the monsoon session, but this is not the end yet. We'll see you soon and we'll be discussing the winter session acts in our next session. So stay tuned with me and follow the revision schedule and keep calm, keep patient, and I hope you all clear your examinations. Thank you.
For more informative content, like, share and subscribe, and do not forget to press the bell icon to get the notifications.